This matter comes on basically to review and approve petition is what it's on for, but at this point, we need to see where things are. Who do I have present on that matter?
I'm here, Your Honor. Amanda Holder on behalf of the guardian and courtney counselor.
Okay.
Sherry Farr, the guardian ad litem.
Anyone? I'm sorry, who else?
Casey Looney on behalf of the state, Your Honor.
Okay.
I'm sorry, I don't mean to interrupt. This is Melissa Royer.
Okay, thank you. All right, do we have Kevin Royer? Okay. All right, so a couple of things that I want to talk about. At this point, guardian ad litem was appointed on January 26th, so I know there hasn't been much time for doing any kind of investigation or report. And so, Ms. Farr, I just want to check in with you. Have you been able to make contact with people?
I've only had a conversation with Ms. Holder.
Okay. All right. Do you have contact information for Melissa Royer?
That is a good question. Let me just check real quick. And
Ms. Farr, I believe on her objection to the guardianship, her contact information is in the bottom right-hand corner of the last document.
that's what I was going to say. I think that all the contact information are on the pleadings.
Okay.
And I will get them. And if I don't have it there, I'll figure it out.
I also, Sherry, I gave you my telephone number on the last hearing.
Okay.
Okay. All right. I just want to make sure that folks could make contact and make sure to talk to the guardian ad litem. And so with that, the other has to do with the status of the CPS reports. I believe Ms. Farr now has a ability to access. I've shared that with the clerks as well to get that report hopefully much faster than what's been going on. So just to let you know on that part. So with that, where are we at? Ms. Holder, you had stated something and I apologize. What were you saying?
I'm not, I honestly do not remember what I was saying, Your Honor. As far as the status of the CPS report, I'm not aware of anything. I have not seen anything related to that yet.
Okay.
Miss Holder's office had sent me a letter for the GLF to be signed for Sherry Farr for her, I guess, talking to the kids and going over there. And I had signed it and sent it back to her office.
Okay, good. All right. Yeah, we definitely need to get the orders signed to get Ms. Farr moving forward on investigating what's been alleged and try to figure out what's best for the children. So with that,
I'm sorry, Your Honor.
go ahead.
Can I say something?
Go ahead.
I have not had any phone contact or anything since June from my children because my sister Courtney has blocked me. And I was wondering if there's any way that I can actually talk to the kids at any time.
Then join it again.
All right.
Hey, is Katie there? Courtney
All right,
Counsel, you have her right now.
I want folks to mute their connection unless they're a part of what we're talking about. It interrupts the recording of what's going on. I don't want to have my focus on trying to mute people. So mute your connection unless we are talking about your case. All right. Ms. Holder?
Your Honor, I believe one of those, the people that was speaking was Miss Counselor, my client, Miss Counselor. Just if you'll let me talk, we can catch up on all that later. What I will say as far as the no contact, the last contact that was made by Miss Royer with one of her children was when she showed up unexpectedly without any kind of notice at the child's school, which resulted in the emergency restraining order that's currently in place. I am more than willing to work with Miss Royer, my client, and the GAL to establish some type of regular supervised phone calls, visitations, or something of that nature. But as to my knowledge, my client has not indicated that Ms. Royer has reached out at all to specifically talk to the children.
Yes, that is
So,
because I have
no,
tried.
stop. Okay, so Ms. Royer, we're in court. This isn't an open mic where you can just say and go and talk whenever.
Yes,
So
ma'am.
what I want to have done is, Ms. Royer, is I want you to go ahead and reach out to Ms. Holder and talk to her about maybe seeing what can be done for at least video or telephone contact at this point. And then that's why we want the guardian ad litem to get going, is because she's going to look into allegations and look into what's best for any given child, and then make a recommendation to the court. So at this time, that's what we're trying to get going here. It takes time. It doesn't happen real quickly, but what I want you to do is reach out to Ms. Holder and talk to her and see if something can get worked out. I know the guardian ad litem hasn't had much time, so it's going to take some time for her to look at things and talk to people. So like I said, this may not happen as fast as you want. But if you work with Ms. Holder, she can work on behalf of her client. Okay.
That's where people.
Thank you, Judge. Sorry.
Okay. All right. So with that, I'm not sure there's a whole lot we can do today. Ms. Holder?
I would just, I think the appropriate thing to do here is to set a review hearing. I believe it would be no more than 30 days according to the statute, since we do have the emergent or immediate guardianship in place. And my understanding is that it, and this will be up to Ms. Farr, is we have not set a review date and or a time when her initial report would be. And so I would like to go ahead and set a review hearing per the statute, and then also ask Ms. Farr, based on what she's first review, when she thinks that her initial report would be available.
Ms. Farr?
Yes, so I'm not aware of a 30-day statutory timeline. I would like at least a month to do my investigation. So if we could set this out for 6 weeks for the review hearing, I think I could probably get a report in by then.
I think the emergency order, is that what you were talking about, Ms. Holder?
Yes, ma'am. Yes, Your Honor.
Okay.
We didn't get one at the last hearing, so there's no emergency order that was presented.
So I don't believe that there's any kind of a timeline on the immediate emergency orders. It's once the emergency guardian is appointed, then there's a 60-day statutory limit that can be renewed once.
So Ms. Holder, there was some problem with me signing off on, I don't know if it was in this case or maybe it was a different case. The emergency, the order, continuing emergency order was not signed. I don't know if it was in this case or not, but I won't sign off on an order that is just signed off by one party. And so if you can't get agreements to sign off, then it needs to be noted on for presentation. So at this point, we need an emergency order from last time. So with that, Ms. Royer, are you okay for Ms. Holder to put approved via Zoom on that, understanding that's what I ordered the last time?
I'm not understanding. What are you trying to sign off on?
So last time we were in court, I had ordered that the emergency guardianship would be continued over to at least today. And there has to be an order that reflects that says that, a written order. And the written order didn't get signed, and it had to do with signatures. And so it doesn't mean that you agree with what I ruled. It just means that it reflects what it is that I ordered. And all it does, it's like the emergency order that you've already seen. It just has the word extended.
Oh, okay. So just continue on like today and then
Right.
next month possibly.
Right.
Okay. Okay. Yeah. I
Your Honor,
didn't see any, nothing was sent over for me to get it signed.
Right, okay,
For-
Ms.
For
Farr,
for clarification, so in this case, the standard petition was filed, the emergency petition has not been filed. So
oh,
only the immediate emergency order that can be extended. We don't have an emergency order.
okay, I apologize, I misstated that.
And I believe Ms. Holder is going to be filing the emergency petition because we just talked about that.
Okay.
sure.
All right, so get me an order with that approved via Zoom on that, Ms. Holder.
Yes, Your Honor. And just so I am clear, the emergency petition you would like to have filed, and then the emergency order. So those are two separate documents. And the emergency order is approved via Zoom, and that goes into the next review hearing date in 6 weeks.
Correct.
Your Honor, wouldn't it be the immediate emergency order that is
I
extended?
apologize,
Yeah.
yes, immediate.
And Your Honor, if I may speak before we end the hearing.
Okay.
I just wanted to inform the court, based on the WICWA reason to know, the state did have information that there's a possible affiliation with the tribe that has not been notified. The Crow Creek Sioux tribe of the Crow Creek Reservation in South Dakota. The note that we have is that there's a possible affiliation for Ms. Royer. And since she's present today, I'm not sure if Your Honor would like to ask her if we can confirm whether that's accurate, to know if we need to send out notice.
Okay, and I apologize, it's the Croy?
The Crow Creek Sioux tribe.
Okay, Crow Creek Sioux tribe, Ms. Royer, do you have an affiliation with that tribe?
I personally, I have no affiliation with any tribe. None of my family has ever had any affiliation with any tribe, as far as I know. I mean, my grandfather was the only one who had a lot of Indian in him, but he never did anything, as far as I know.
Okay. And are you aware whether or not the biological father has any affiliation with any tribe?
No, he does not. He barely has any Cherokee in him at all.
Okay. All right.
He's mainly French and Italian, so.
Okay, thank you.
You're
So,
welcome.
Ms. Holder, I would go ahead and get a letter sent off to that tribe to try to see where Ms. Royer stands in relation to the tribe.
Absolutely.
All right, thank you, Ms. Looney. Anything
Sorry.
else today, Ms. Looney?
No, Your Honor.
Okay, so we need to have a date. Ms. Holder, what date are you proposing? Or Ms. Farr, what you were saying 6 weeks?
I would prefer the 6th or the 13th of March for the review, and I should be able to get a report in, at least as to the emergency order at that time.
So it should be the 7th or the 14th.
Oh, I'm sorry, I was looking at the wrong day.
It's okay. Ms. Holder, do you have any preference?
I would prefer the 14th, Your Honor. I am probably going to be out of town the weekend of the 8th.
Okay. All right. Ms. Looney, does that date work for you?
That was March, Your Honor. I'm sorry.
Correct.
Yes, that's fine.
Okay. All right. Anything else for today?
No, Your Honor.
Okay. So Ms. Royer, I want you to reach out to Ms. Holder and see about working out at least a video or telephone call plan. And then if you can't get it, you can always put it back on the docket and we can talk about what needs to happen then. Okay.
How would you, if I didn't get it, how would you put it back on the docket?
You do a note for docket. And let me ask you this, because I'm stepping into some of these cases after they're already going, you have a right to an attorney. Did you ever make a request for an attorney?
I had the order for attorney, but I didn't know exactly what to do on it. I put the paperwork in, but I think it got rejected because I didn't have my address and stuff on it. And I was looking at it and I was really confused on the paperwork.
Okay. Why don't you talk to have they just been doing this verbally? Yeah. So can you give me a sense of what your income is?
Well, kind of varies because I'm a lease purchase truck driver, and for the last 5 paychecks, I've had 0 paychecks because they take out the payment and all these other fees. And so I
Right,
haven't
so-
had a paycheck for 5 paychecks.
So tell me, and different jobs
But-
can vary about, so for 2023, can you give me an idea of what your income was?
Probably less than $30,000.
Okay,
But but if you look at gross wise for the owner operator lease to own thing, it's way more than that. But net wise, that's about it.
Okay.
Yeah, it's not very
Okay.
good.
why don't you submit your information and talk to the clerks about what you may need to do differently, because this is kind of on the border of whether or not you would qualify for court-appointed counsel. So why don't you do that, talk to them, and then we can take that up at the next hearing, okay? So for
Okay.
now, our next hearing is going to be March 14 at 10:30, and then we'll go from there, okay?
Okay. All right. Thank you, Judge.
All right, thank you.
Thank you, Your Honor.
Apologize. So this was set on primarily, I had said this matter needed to get going and get set for trial. So did it get on a trial assignment? Oh, let me back up. Who all do we have here? We have Ms. Holder, we have Mr. Anagnostou, anyone else?
This day.
Day, Guardian ad litem.
Okay,
And my client is also here, Mr. Jeffrey DePriest.
okay. All right, so I had wanted this matter to get moving forward, get set for trial if you couldn't reach an agreement. Where are we at with things?
Your Honor, we have we are on the universal trial setting docket for February 28th.
Okay. All right. That was the main thing that I wanted to make sure got done, and moving forward. So, anything else that needs to get addressed today?
No, Your Honor.
All right. So with Mr. Anagnostou, anything from you?
The only thing is I spoke with my client, and she indicated she's been denied getting visitation. There's already, I believe, an order allowing her to have time with her son, but she says that's being denied by Mr. DePriest.
Well, the matter is not noted up for today. I would suggest note it up and we can address it, and then I can have some documentation as to what exactly is being stated and what the response is.
Right.
Okay.
Yeah, she just, I spoke with her today, and that was the information she gave me. So I'll get something filed.
All right.
May I speak, Your Honor?
Mr. DePriest, we're not going to address that issue today. You have an attorney.
Okay.
All right. So do we want to set a review hearing? What are your thoughts?
Probably 2 or 3 weeks for me to get something filed, Your Honor, and then opportunity for a response.
I don't think that we need to set a review. I think we can just leave it to Mr. Anagnostou to file the motion. We're set for a trial assignment. That's really the next step. If he wants to file a motion, then we can respond when that's noted up.
That's true.
Yeah, that makes the most sense. I don't want to have hearings just to have a hearing. So, so as long as we have it on the 28th, I wanted to make sure to have it go forward on that day. And then note up your motion and we'll just go from there.
Okay.
All right. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
That matters ready, Your Honor.
Okay, we have Ms. Winkles.
Yeah, Mr. Radcliffe.
Okay.
Good morning, Your Honor.
We have Mr. Gooday.
And Sherry Farr, the guardian ad litem. Although, Your Honor, I was appointed verbally, but I do not have a written order yet.
Okay.
Is there a way that I could ask for a
Hold on, Mr. Radcliffe.
apologize?
Okay. So, in regard to the guardian ad litem order, Ms. Winkles.
Yes, Your Honor. We'd also ask for Ms. Farr to be appointed. I'm sure the dad, Mr. Radcliffe, would also like that, so we can move this along. What we're asking for today is pretty simple. Just no contact with the child. The child's not seen dad in since the child was an infant. Just no contact until the GAL has a chance to review. That's all we're asking for today.
May not carry that B designation, but regardless, I want to take care of a couple of things before we get going. First off, Ms. Farr, if you can just stay on after we're done, we're going to try to have a short meeting so yeah, we're going to try to do that.
Okay.
We have signed the orders. There does need to be an interlineation of for the GAL on the other section of the GAL order, but I believe everybody has agreed to that. We just need one line that I apparently missed.
Okay. All right. Anybody else wish to speak to that? So do we need any future review date or anything of that nature, Ms. Winkles?
I don't believe so. We'll docket that, but I just wanted on that GL order under other to say the GL has the authority to investigate the current the visitation of mother and father so that she can update the court on both of them.
Okay.
I don't see my clients here, but I'm assuming we'll have a court date once the investigation's proceeding and things of that nature.
I was going to docket it, but give a little bit of time for the GL to do the review.
Sure, thank you.
And you
And
said
if you-
that's which matter?
That's the Aldrich, Serenity Aldrich.
Okay. All right. With that, if there's no objection, I will go ahead and strike or call that done.
And did you want me to get you the new order with the language, or do you want it to just interlineate yourself?
I don't have any orders.
Okay.
So-
Well, that makes it easy. I will make sure my legal assistant runs one over this afternoon with that language in it.
All right.
And
All right. That takes care
we
of
have
that
signed off on
matter.
an agreed order. I believe I got a copy up to your honor. For the next review date, it is set for today's date because that's what it was. But the Guardian ad litem has asked that the matter be set over a couple of weeks. So for whatever schedule she's requesting, I'd like that date filled in for the next review date. And we have Mr. Esau here and Mr. Sasaki.
Okay. Counsel?
Morning, Your Honor.
Morning.
This is Don Esau for the mother, Georgia Woldridge. We agree with the order. My client's curious about the visitation and what Ms. Farr was able to find out about a reconciliation counselor as the court ordered back in January. So I don't know if we have. Go ahead. Sorry.
Excuse me, John Sasaki, counsel for the father. That is correct. The new orders or the order has been circulated and agreed upon. But I would agree with Mr. Esau regarding if it could be entered in an interim order on the visitation.
Okay. Well, it doesn't sound like we necessarily have a full agreement. It sounds like one thing is agreed, but so with that, I'll just go ahead and take that matter up at this time.
I believe the request at this point, Your Honor, is for more time for Ms. Farr to complete a interim report. I believe that's what she's working on. It might be a final report.
Just a moment here. All right, so let me talk to Ms. Farr for a minute. Ms. Farr, what at this point, any changes at this time? Any chance of looking into this counselor?
Okay, so there's a couple issues. So I have looked into the counselor. Charlotte Rosen has agreed to do the reunification counseling. She needs a court order though that specifically says how that reunification is to go before she'll start the reunification with either parent. The other counselor, the existing counselor, will then just continue with Flynn on the other issues that he needs counseling for.
Okay. And Ms. Farr, do you have any suggestion about the reunification at this point, counseling? Are you thinking an hour a month to start, or what are you thinking?
Well, right now, both parents are exchanging, alternating their turns. But I think that's because there wasn't a counselor to facilitate it. I will say that Flynn is having some difficulty with these phone calls, more so with mother than with father. His phone call, he's having some aggressive behaviors and outbursts after the phone calls have concluded with, for a day or two after. So those issues are being addressed as well, but right now they're having one phone call a month. So if Your Honor believes that that is still where we should continue going and do this slowly, I think that would be the best for Flynn, because he is having some issues adjusting.
Counsel?
This is Don Esau. I have a need for clarification on that from Ms. Farr regarding, are we talking 1 hour per parent per month, or are we talking alternating hours for each? I guess I didn't say that very well, but is it going to be the mother 1 month with 1 hour, and then the next month will be the father with another hour? How is that going to work?
I think it should be 1 hour per parent per month. The other issue is who's paying for the reunification. That also needs to go into the order for Ms. Rosen. So the parents should be paying for that reunification to be happening.
Did you happen to ask her what she charges or anything?
I did not.
Okay.
Ms. Barrett also was involved in contacting Ms. Rosen and talking with her too. So Ms. Barrett might have a little more information. And Ms. Rosen is the one that shared with Ms. Barrett that she needed the court order.
Okay. So, Mr. Anagnostou, any information on that?
I don't have information regarding that. If we want to inquire from my client, he is present.
Okay, as long as you're okay with that. Ms. Barrett, just want to keep this focused. Did you happen to find out what the hourly rate is?
Yes, Your Honor. Can you hear me?
I can.
Okay. Charlotte charges $300 an hour, but she has interns that work for her that we could work with that charge between $30 and $80 an hour.
All right. Counsel, with that, I'm assuming an intern would be acceptable.
Yes, Your Honor. I think my client would agree with that. I don't think she's on the call today, and so I'd have to talk to her. But of course, I think 1 hour per parent per month sounds reasonable. And if they have to pay for it, we probably better go with the least expensive, since we have court-appointed counsel for each of them and can't afford much.
Okay.
Likewise, I'm sure my client would prefer the lower rate with the intern and would have no problem with that.
Ms. Farr, did it happen to be discussed as to, are they supposed to call and make an appointment to schedule this time, or how were they looking at that?
Yes, the parents should be contacting Ms. Rosen's office to get that scheduled once she receives the order.
Okay. All right. So with that, I will go ahead and order 1 hour per parent per month at the and the parent is responsible for making the payment of the reunification counselor, each responsible for their hour that month, that the reunification is to be done by an intern at an intern's rate. And that the parents each are to schedule their time for that phone call with Ms. Rosen's office. And
Subject to the approval of Mr. Anagnostu's client, then they would all have to agree on the time so that
Right,
Flynn can get there or
right.
get, yeah.
Yes, you could add that in there as well.
Okay.
So I'm not sure which one of you is going to prepare an order.
I can do it, Your Honor.
Okay.
Unless Mr. Agnostu, sorry.
Anagnostu wants to.
Yeah.
Okay. I'm thinking that we should probably set a review. What date were you talking about, Mr. Anagnostu, for a review?
I was actually inquiring with regards to the Guardian's schedule. So the order that I submitted goes through today is a review date for today. We need to strike that out and put in whatever date is appropriate. But I think we're waiting for a Guardian ad litem report, but I'm not sure. So it's whatever schedule everybody needs. So.
Well, I can tell you there are some issues that I went through the record to try to figure out what was done, what wasn't done. And the one thing that I see is obviously we've had some troubles with DCYF records and not getting them. And I'm not sure where and why that's happening, but for the attorneys and Ms. Farr, if you want to wait until the end and we're going to have just a short meeting, I would ask that it be focused on the attorneys and Ms. Farr and Ms. Day if you want to join. We're going to try to talk to the clerk to see what's going on procedurally of why those aren't getting through. Anyhow, so I think that's one issue I saw. And then I guess that was the main issue. So Ms. Farr, I'll defer to you as to where you're at otherwise.
So, Your Honor, we have the emergency order was entered, I believe, in September. So that is supposed to be, maximum 4 months. Then it gets set for trial or review hearings or whatever, wherever the court directs that this is going. And then I would prepare my report before that review hearing or trial date or whatever.
Okay.
So I think that's where we're at. We probably should set it for, get it on to set for trial, I think.
Mm-hmm.
You think we should try some reunification counseling first?
I do.
Okay.
At least for a couple months, since it's only one phone call a month per parent, we need a little bit of time for the counselor to make some recommendations.
Okay.
And whoever is preparing that order, if we could add the language in the order that says that I'm allowed to access records or speak with the counselor about that reunification.
I think what we'll do is let's go ahead and set a review of April 11. And I'll write that into the order. And then at that time, we'll go ahead and see how the counseling is going. And on that date, meanwhile, I also want to see where the DCYF records are because we do need those. So let's talk about a trial setting after that April 11 date. So if you want to get it noted on for trial setting, but ask for a date after that April 11 would be good.
Okay.
So put it on the universal trial assignment docket after April 11th.
Well, set it for a date after that April 11th. So you can get it on anytime, just set it for after then.
Mr. Esau, you want me to prepare the order from today? I'll do the order.
Oh, okay. Yeah, that'd be fine. Thank you.
I think I got everything and I can get that in the order.
We certainly can work on that.
All right. All right. If nothing
Your Honor,
further,
if I may.
Go ahead.
I have one more item, if I may, regarding the motion filed for the compensation of attorney's fees for John Kasaki, counsel for father.
Okay. I deal with those ex parte. I don't deal with them on here. So have you submitted it ex parte?
No, it was served on all parties, but we can submit ex parte. No problem. We'll do that.
It should be done ex parte, and and it'll be reviewed at that time by a judicial officer.
Understood. Will do. Thank you.
Okay, all right. So I've signed off on the order.
And you interlineated the new,
April 11, 24.
perfect. Thank you.
Yes.
Your Honor.
Okay, all right, thank you.
Thank you, Your Honor.
Who do we have on that matter?
Well, I am present, Your Honor, Sherry Farr.
Okay.
Yeah. John Sasaki, counsel for the father.
Okay.
I was advised that I didn't need to attend this hearing, but since I was just on, I can stick around just in case there's anything
Okay.
required for myself.
All right, and do we have the guardians?
I am not seeing her, but I know that she's had some misunderstandings about when these hearing dates are.
Ms. Farr, do you mind making a quick phone call and?
I can.
Okay. Who do I have here on that matter?
Your Honor, Curly Bliss on behalf of the minor Keelan.
Kurt Anagnosio on behalf of the mother, Danielle Jones.
And Sherry Farr, I was appointed verbally as the GAL.
I'm Vicki Jones, representing myself in this matter, temporary guardian.
And I am Chuck Jones, Kayla's uncle, representing myself in this matter as well.
Okay. All right, so that was one thing that I noticed is that Ms. Farr was appointed, but there's no order, I believe. Well, let me look.
And Your Honor, I did send over a proposed order. I had drafted that order shortly after our hearing. I got signatures from the guardians. I did not receive Mr. Anagnostu's signature. We attempted to follow up a couple different times. So I simply prepared it and provided it to the court as a proposal in hopes that we could get that order entered today, absent any objection from Mr. Anagnostu. I did note that Ms. Farr was appointed, obviously doesn't have that order appointing her. So I do know that that's stalled, kind of her process. So it was my hope today that we could get that order entered and then maybe set the review over to allow her the opportunity to obviously begin her investigation.
And Ms. Bliss, I don't believe I've seen that proposed order.
Let's see. It does not look like my assistant sent that over to you. I will do that right this moment.
Okay, thank you.
Mm-hmm.
And Mr. Anagnostu?
Well, Ms. Bliss, I guess I have, is that a separate order appointing the guardian ad litem, or is it just the order that you provided to me that had the one line in it?
It was simply that order on that January 4 hearing, and I did include that she was reappointed in that matter.
Okay. Well, yeah, you did. I thought there would be an order appointing, and I guess since it's a reappointment, potentially we can handle it in that manner.
That was my hope. I mean, obviously, if we need to enter an official secondary order appointing, then I can do that. I just wasn't sure if we could just enter that she's been reappointed and then rely back on that initial order appointing.
There wasn't an initial order.
What's that?
Sorry, Your Honor. There wasn't an initial order. I never had an official order appointing me, even the first time around. So
okay, and that's my misunderstanding. Yeah. I can draft that order and get that out to the parties today. So that's my apologies on that.
Okay. All right. Let's go ahead and get that other order. And I agree, even if there was one with her just being even reappointed, I would still want another order.
Okay.
So with that, Mr. Anagnostu, have you seen it, the order that is proposed?
Yes, I have seen the proposed order, and we had an issue with regards to the visitation, and I apologize. I did not have an opportunity to get a hold of Ms. Bliss before today's hearing. The issue is the way she has set out the visitation. My understanding is my client has two separate opportunities to have contact with her daughter. One is through a mutually agreed upon person that will supervise, and then the second is reunification counseling. And the reunification counseling should be something that my client gets to set up, and the mutually agreed upon person is for kind of immediate visitation, so she can start having some contact with her daughter. But the reunification counseling was separate, and that should be something that she can pursue and organize, is my understanding of your ruling from the last hearing. And this just sets up one way of getting visitation.
Your Honor, it was
ahead.
stated in the last court hearing that Miss Jones would like to have an old boyfriend be the person appointed to be the neutral party for Kayla and her mom to be reunified. That is inappropriate. It needs to be a professional party to reunificate these two people together. They have not had a relationship since Kayla was 11. She is now 16 and a half years old and is refusing to speak to her mom, to text her mom, or to go see her mom. Our hands are tied. She's 16 and a half years old. We need the assistance of the court and Sherry Farr to move forward with this reunification between this mother and daughter. Thank you, Your Honor.
Ms. Farr? Any thoughts on that?
I cannot speak because I haven't spoke to any of the parties.
Okay.
I only know what I've read in the court records, but because I haven't had an order, I haven't started interviewing yet.
Okay.
So it's my request that we enter an order that indicates if they can come up with an agreed third party. I understand they have an objections to the proposals now, but if they can, that's one form of visitation. Then the other form is reunification counseling that my client can organize with a professional.
And that is included in my order. So if you review the order on January 4, 2024 hearing, number 1 says reunification counseling shall begin immediately between the mother and child. And then 2 goes on to discuss visitation between them with an agreed upon third party. So I'm pretty sure my order encompasses those concerns.
The first paragraph indicates it's reunification counseling as a agreed provider. And I don't think that's part of the issue. My client should be able to find a provider and get reunification counseling set up.
I don't have any objection to changing that language instead of agreed upon, just a provider. I just think at this point, we haven't even been given any proposals for a provider. So
Mr. Anagnostou, is your client someone here locally? Because it sounds like that might be I don't know if you were part of the last hearing and we were hearing about Miss Rosen and the interns. And I'm just thinking of the cost, that might be a really good option. I don't know what your thoughts are there.
Well, I just heard about the intern costs and I will get that information to my client. My client is in Portland, the area, but we need a mechanism to move forward on the reunification counseling. And so that should be, she arranges. And then in addition, and the order is not clear that she gets visitation if they can agree on a third party.
All right. So looking at the order that Ms. Bliss has put together, it reflects what I was talking about. I want agreements. If there aren't agreements, it needs to come back. So if the parties don't agree as to who that would be, then okay, you don't agree, you can bring it back and we can talk about it. If it's an issue that the 16-year-old or the child doesn't want to have contact and the reunification counseling needs to come first, then that's okay. I don't want to force her into doing something, and that's where the reunification counseling is at least moving it forward. So I agree with Mr. Anagnostou is that it gives both options. I can simply take the only concern I have is what I don't want is mom can't get up here where the child is and just stop and wants to have the child come to Portland for that counseling. That's the only concern that I have. So it needs to occur where the child, in the area where the child's located. So I'll go ahead and put this should occur at a provider designated by the mother. And I just want to make sure that the child is in Cowlitz at this point, correct?
Correct.
Okay. So I'm putting in the Cowlitz County area.
And Your Honor, when you say a provider, you're referring to a professional provider?
It's a reunification counselor, so.
Thank you.
Yes. All right, so I've done reunification counseling shall begin immediately between the mother and child. This should occur at a professional reunification counselor provider designated by the mother in the Cowlitz County area. Okay.
Perfect. And with that, Judge, I'll get that order appointing Ms. Farr, the official order. I'll get that out to the parties today.
Okay. So, Mr. Anagnostou, are you okay to put approved via Zoom?
Yes, Your Honor.
Mr. Ignacio, I sent you a message. If you could check that, that'd be awesome.
Okay.
All right, I have signed off on that order. Okay, anything else for today?
Nothing.
Only,
Thank you, Your Honor.
All right.
Your Honor, with regards to this case, before we leave, I was just wondering, with regards to can the visitation my client set up, can that be by phone? I mean, can she have some phone contact with her daughter?
Okay, I've already ordered what I'm going to order, and I want it by an agreed third party that's going to be supervising it.
Okay.
All right, and do you want to go ahead and set Ms. Jones? Stop.
So
stop.
Then I want to fire my lawyer then. Like, I'm supposed to have text messages and she has no phone. So how am I supposed to be able to message my daughter?
I want to know, counsel, do we want to review?
Yes, Your Honor. I mean, I'd like a review.
Okay. All right. Do you want to set it out month, or what are you thinking?
2 weeks, Your Honor.
Well, I want to give enough time for mom to get the reunification counseling set up. That's the only reason I would say that doesn't probably work.
I also need some time to interview as soon as I get the order.
Okay. All right, let's go ahead and set this on to March 7 at 10:30.
Right.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Thank you.
Okay. So a couple of things. One is we're still waiting for the DCYF records, and hopefully we'll be trying to get something there. So where are we as far as the guardian ad litem?
Your Honor, so the only thing I'm waiting for is the CPS records. That's the last piece before I can complete my report and we can prepare the findings.
Okay. All right, who else do I have here on this matter?
John Sasaki, counsel for the father. And the only thing that I had was just requesting that we be to be included in the orders that on dismissed in the order, final orders.
Anyone else here on this matter? Okay. So, at this time, it seems like we're just waiting for the DCYF records. So do you want to set this over a month to see if we get those records, or?
Yes, I think that would be appropriate.
Counsel, would you agree?
Great, no objection.
Okay. Okay. All right, so let's go ahead and set this matter over to March 7 at 10:30. And then hopefully, fingers crossed, we'll have the records and we can go from there.
And
okay.
Do we need a order extending to that?
Oh, yes,
yeah.
we do. We do. Thank you. I can go ahead and prepare one. Who all is here on this matter?
Aaron Winkle's appearing on behalf of Carol Lavender. And my client is in court today as well.
Morning, Your Honor.
Jennifer Lavender.
Morning, Your Honor. Jim Sansone, appearing for the guardian, Joey Thomas.
Goyak appearing for Jason Thomas, the father.
Anyone else?
Carol Lavender, I'm present.
Okay, thank you.
And Miss Day is here as well as the guardian ad litem in the case.
Thank you. I was just getting ready to say that. Thank you.
Okay, thank you. All right, so Ms. Winkles, I understand you're asking for some additional time, is that correct?
I am. I had no idea how much had been done in this case and filed since I was last on it. It took me a week just to go through everything. I did prepare a guardian ad litem order, which is with the court. I believe we have most of the signatures, not all of them on that. If Miss Day can give her yay or nay on that, I believe her signature is the only one that was missing on that. If there was any additional language she wanted. Other than that, I would ask for a 1-week continuance just because, again, I had no clue that within the last 6 months or so much would be done.
Okay.
I don't believe I've seen the guardian ad litem order, so I don't know. I assume it's just the standard.
It's the standard with electronic, gives you the permission to use electronic means, Facebook, all those things to communicate with the clients. That's the only difference from the standard order.
Perfect. That's fine. I have no objection.
Okay. With that, anybody else have any objections to it? I don't have the order, Ms. Winkles.
Okay, we'll get it to you. I believe it's with the clerks, but it's probably just not made its way back.
Let me see. No. So yeah, I don't have it.
Okay, I'll make sure that gets back to you.
Sorry. Okay.
Partner, I guess my only question is, do we want to do a 1-week set over, or do we need more time to give to Miss Day to do her assessment and do a report? That would be my only.
Just a minute. Have an order. That looks like it's from Mr. Sansoni. I still don't have anything from Ms. Winkles.
Okay, we filed the proposed, but we gave you the original, but again, it might just not be back there yet. So what we'll do is we'll provide another one just to make sure it gets back.
Okay, so do you think a week is going to be enough?
2 weeks would be better for me, and it also will give Miss Day kind of a little bit of time to come back with at least an informal oral report, and then maybe the written report we can set at that time after she knows how much time she needs.
Okay.
I think that makes sense. I have been active in this case since September, but without a proper order, I've had a lot of difficulty getting records. So I did recently get the school records and some of the records from Columbia Wellness. So those came in on Friday, and then I need to set up a time to see the children with mother and do some follow-up. But I think that if we set it out 2 weeks, I can at least give you an idea of how much, if I need more time, and what more time I would need.
Okay. So that would be to March 14, or 2 weeks, sorry. That would be to February 22nd. Would you mind going to the 29th, just because I'm gone most of that week?
That works for me.
Okay.
That's fine, Your Honor.
Okay.
Yes, that's better for me, Your Honor, so thank you.
Okay. All right. If that works, let's go ahead with February 29 as the next date.
Your Honor, I actually have a hearing that morning.
Okay. What time's your hearing?
It is 1 o'clock Eastern, so that would be 10 o'clock Pacific.
Okay. The other thought is to set it to the 7th. That's further out.
And that still works for us. As long as my client can record the video visits between the children, I don't think anybody would have a problem with that, considering it'd just be her and the children. That would be our only issue, so that we can provide those to the GAL. If nobody has an issue to that, we have no issue going out to March 2nd.
Is it March 2nd or March 7th?
March 7th.
7th is fine, as long as my client can record those visitations to provide to the GAL.
Anyone have any objections to that?
Well, I guess I need a clarification. Are we talking about recording the video visits or the actual visits?
The video visits, I think the actual visits would be really difficult to record because then the kids would feel they were on camera. With the video ones, you can just hit a button.
Okay, I have no objection.
Mr. Thomas, do you have sorry, I haven't had a chance to talk to my client about that. Mr. Thomas, do you have a position on that? Do you care if they're recorded? That's fine with us, Your Honor.
Okay. All right. So hearing no objections, that's as long as it's just the video ones, then that's fine. And then we'll go ahead and just set it out to that March 7th date.
That works.
Okay.
Would you like me to get an order continuing along with that JL order?
It's always nice to have, just for the record.
Will do.
Thank you, Your Honor.
All right. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Good morning, Your Honor. Delana Jones here on behalf of Mother Marlene Melton, who is present on the Zoom platform this morning.
And Christine Dow, who is here representing the guardian, the temporary guardian, Jamie West, who does not appear to be here.
I'm here.
Oh, okay. Oh, sorry. There you are.
Okay, I do it too.
Also here.
Okay.
And Sherry Farr, guardian ad litem or court visitor.
All right, thank you. So I went through the file just to see where we were at with things. The DCYF records were requested back in August of 23. We're trying to solve and figure out why we're having so much difficulty there. Excuse me. We have our court visitor order that was done back in the fall. So let me ask first, Ms. Farr, where are we with that?
I provided my report to the attorneys this morning. It hasn't been filed with the court yet. Okay, good. All right. So with that, it looks like it's primarily having to do with the DCYF records and getting those. So counsel, any thoughts at this point?
Your Honor, Ms. Jones is definitely going to need time to respond to the court visitor's report. I'm going to need some time as well. I'm thinking that unless you direct us otherwise, if we can decide on a date, and I'll defer to Ms. Farr for that, I'll get a continuing order in place, get it over to Ms. Jones for her signature and get it to the court today. And hope that between you and Ms. Farr, we can sort out DCYF.
That's correct regarding the mother's position. We do want some time to respond. I was proposing a specific date of the 22nd, 2 weeks out from today. It sounds like that may not be enough time to address the DCYF records, but we were mainly focused on time needed for response to the report, reviewing it, speaking with the mother about it.
We could go ahead and set it out a couple of weeks, and then if you need more time, it's fine to go ahead and set it out further if that's what's needed. So do you want to just do a review see if response to the guardian ad litem report can be done by then?
Yes. Your Honor, I'm fine with that. However, if just in the interest of efficiency, if Ms. Farr thinks that we can see the DCYF records within 3 weeks or even 4, if nobody objects to that, maybe we should set it out a little bit further.
And I can tell you in regard to there's no guarantee. We're hoping that we'll try to resolve the process as to why we haven't been getting those records. And so I don't know. I mean, a month is fine if you think that would serve everybody's interest.
Your Honor, I'm fine with that. We have been working pretty well together to have some regular time between the child and his mother. He's also still safe with the guardian, so I don't think there are any issues particularly with that. If everybody else agrees, I would be fine with a month.
That work for everyone?
I mean, I haven't had a chance to speak to the mother about that. We did already speak about the need for a continuance in general. The mother has been having more consistent contact with the child by agreement with the temporary guardian. So my hope would be that that continues. I mean, something previously we've done is we've continued it to a couple weeks and then by agreement off record have continued the hearing out further. I suppose that that would be our preference.
That's fine with me, Your Honor.
All right, let's go ahead and just continue it a couple of weeks and then go from there. So that would
So
put
that
it
would be the
on
22nd?
to yes, February 22nd at 10:30.
All right, I will get the continuing order over to you to you, Ms. Jones, very shortly and to the court this afternoon.
Okay, sounds good.
Thank you, Your Honor.
Thank you.
Thank you.
All right, that concludes the docket. I am going to end.